bad is your H-1B status? How much are you in compliance? The most common pitfalls of your H-1B is our discussion today. Now, specifically, it's not about H-1B rules or what the employer can and cannot do. It's about you as an employee, what mistakes could happen, what circumstances can affect your H-1B. That's our discussion today. I'm Sam Shihab with Shihab Burke, and with me is
Brian Burke. Howdy, Sam. Good Monday evening to you.
How are you?
I'm doing okay. You know, we've been talking for the last sitting here talking for the last 20 minutes, but that topic never came up.
Yes.
A good old classic, Sam and Brian YouTube topic for the night, I think.
A lot of things that can happen that you are not prepared to address, and if you listen to one of these YouTubes, whether with us or someone else, and learn a thing or two, it would be great. Most common H-1B pitfalls that affect you. We're going to spend 10 or 15 minutes discussing this topic, and then we're going to jump into taking your questions because your questions are important to you, and we will take care of them as well. So let's dive right in.
Yeah.
But probably before we do that, maybe we should let everybody know we are at immigrationvisaattorney.com. We practice immigration law throughout the U.S. We do employment immigration law and family immigration law. We have multiple attorneys here with over decades of experience in immigration law and have experience in the field. So the first issue, Brian, is
failing to check those I-94s when you enter the United States. A classic H-1B issue, or really an issue for everybody coming to the United States as a non-immigrant. But a lot of people don't check their I-94s when they enter the country. They assume they got what they think they should get, and it can become an issue down the road.
Historical perspective.
Yeah.
I don't know when that changed, 5 years, 8 years, 6 years ago, I don't know. I don't remember. Maybe 10 years ago.
The paper to electronic
Yeah.
I-94 transition? Yeah.
Sometime in the last 10 years.
Yeah.
So before, they used to hand you two cards, a customs card and an immigration card. They say, if it's an international flight, they say, if you're not a U.S. citizen, you need to complete this card. You complete it, put your name there, and that's your I-94, which is the officer takes and then stamps it, separates it, puts on the date, hands it to you, and you can immediately inspect it.
Yeah.
That has changed. Now you guys live in a new world, a world in which the officer stamps and hands you the passport, and then you go after you are in the U.S.
cbp.i94.dhs.gov, something along those lines, and
then look it up online.
Yeah.
Within 24 hours. And that's where the problem is. People don't do that.
yeah. And I mean, there's for me a real common one is the shortened I-94. Let's say you come in with a passport that expires in 8 months, but a H-1B approval that expires in 2.5 years. You think you're going to get a I-94 for 2.5 years. Well, they'll sometimes and often usually line up your I-94 expiration to the end of your passport. And if you don't catch that and you say, I don't know, stay beyond the I-94, you have trouble.
And that's the first thing that we see time and time again. So make sure to check your I-94 online when you come in, because there are consequences that are serious.
Yeah.
What is the first serious consequence, Brian?
Oh, well, it's the 3-year, I can group them together, but the 3-year, 10-year bar. It's if you are unlawfully present, if you overstay your I-94 by more than 180 days, but less than a year, they will ban you from entering the United States for 3 years.
Even if that I-94 was given to you with the wrong date.
Yeah. Oops, it was your mistake well, there's ways you can argue that, but it's not really easily fixed.
So the consequences are serious.
Yeah, you go beyond a year or more, they're going to bar you from the country for 10 years. Now, well, yeah, if we move on to how to address it, I guess the number one thing we always tell people is, if you leave the country after that has occurred, you've kind of accepted that bar and you're going to have some serious, trouble coming back.
There's a waiver.
Yeah, there's waivers.
There's a waiver at the consulates, but good luck with the waiver because...
It's a long process.
Well, not only that, but to argue to the consulate that it was an error that you didn't see, it may not meet the letter of the waiver.
Yeah.
The criteria.
Yeah. Nunc-pro-tunc requests, if you're still in the United States, can work.
What's a nunc-pro-tunc?
Nunc-pro-tunc, that's one of those, Latin lawyer phrases, which I think it means as it was, The idea being that you file an application with the government and say, please, something really crazy happened here. Please accept, an extension on my behalf as if I had filed it timely. They're usually pretty, what can I say? We have a lot of people come to us for help with when they oops their I-94. And we have a pretty good success rate on those. It is, it is surprisingly easy to sort of, blame somebody else when your I-94 goes awry. And USCIS, in my experience, has been often willing to take those arguments. Also,
there is the opportunity to go to Customs Enforcement Office, the nearest one, and they are published online, and ask for an appointment and request a correction if you put forth and present and prove the correct argument that it was an officer's error, even though they were given the correct information, they can do it. They can fix it.
Yeah.
And that is the least painful and least expensive and most effective if you're lucky.
If you're lucky. You have to be pretty lucky to get those. It seems, I remember for a while I was doing it and having great success. And then they've sort of, maybe the word got out on that issue, perhaps. Yeah. So
okay, so
number
that
one,
is the first one.
Yeah,
okay,
failure to check your I-94s upon entering the United States.
The second one, Brian, is
failure to timely start the green card process.
Failure to timely start the green card process, because by timely starting the green card process, what happens?
Well, H-1B folks get 6 years to stay in the United States. And if you get your green card process to a certain point before your H-1B time is up, you can extend your H-1B beyond 6 years. And, well, the challenge here is that the green card process is getting longer and longer and longer and longer right now.
But that doesn't affect it because you really need to file within 1 year. The problem is the prevailing wage also.
Well,
to file, let's go through the rules first.
Yeah, sure.
So the rule is that you have to have a labor certification filed and pending for at least 1 year, or
that'll get you 1 year extensions of your H-1B status. Yeah.
Some extension beyond 6 years.
1 year.
Yeah. Or you have an approved I-140.
Yeah.
That will give you the 3 years.
Yeah.
Okay. Therefore, if you don't start the green card in time before you hit your 6 years, then you may not have the opportunity to extend beyond 6 years.
Yeah.
And we can go through the timeline, and that's not the purpose of this presentation. The purpose of this presentation to highlight these things. So when do you start the green card, Brian? Timely, so you don't run into that problem.
As soon as you can convince anybody to undertake the process for you is my answer to that one.
But no later than?
I would say you want to leave yourself 3 years any more to get a clean I-140 approval before your time is up. Because I would say,
But if somebody with 2 years, do you think they're in trouble?
I think on an ideal scenario, about 1.5 years to get an I-140 approved, right?
Well, you can go 1 year. My timeline is a little bit different than yours.
Yeah? Well, okay. I mean, there's ways to speed it up. Go.
Well, no. I'm not talking about speeding it up. I mean, I'm not talking about, time. What's timely? Timely is as soon as possible, correct?
Sure.
But what's that window of time cutoff after which you're dead in the water? I'm gonna say probably about maybe 20 months, because I got to do the prevailing wage today.
Yeah.
So this is November 20th, 2023, right? We put a date so people know that timeline can change. So today, a prevailing wage is 6 months.
Another 2 months minimum to do recruitment.
45 days before to collect information to do the prevailing wage.
Sure.
Okay, and then you have, I'm going to say 90 days for recruitment, Brian. Because
that's a more conservative amount because time frames.
Yeah, because you know the case comes to your office doesn't mean you're going to grab it the same day. I mean, the attorney is not like he's sitting.
There's human beings working on
watching
anybody's
TV, waiting for.
cases. Yeah.
So 90 days. So that's 4 months plus 6 months.
10 months, and that's
10 months plus 12 months to get the 1 year.
Well, yeah.
So I'm going to say 2 years.
Yeah.
2 years for me is once you cross the 2 years, you are now, congratulations, entering the red zone.
Yeah, I mean, there's ways you can do it. If you join a company that does a lot of green cards, you can probably maybe reuse another prevailing wage, or if they have, or you try to bump somebody else out of the process and take over theirs if your company really wants you. But the processing times are really quite brutal.
We have clients that do continuous recruitment.
Sure.
And these people, you can probably file the green card ridiculously fast.
Yeah.
Because they spend money up front, because they constantly recruit in a certain field, in a certain area, and they're constantly looking.
They know what kind of people they want, and they know they're going to keep on hiring.
And the prevailing wages are filed, and they are issued back, and the job descriptions are all drafted. The question becomes whether or not
you can meet the requirements.
You can meet the requirements, which if you're hired, most likely you do.
Yeah.
So these companies, you're jumping on the train as the train hitting 100 miles an hour.
Yeah.
Okay, that's basically what's going on. But that is not the rule. That is the exception.
Yeah.
The rule is a company starts from the beginning, as they fire the engine and go through the process.
Yeah.
It takes about 2 years.
Yeah, I mean, and depends upon company culture. If you're working for a great big giant huge hulking company that does these things slowly, you can't really really account.
Company with huge red tape. It can take a while.
And that doesn't account for things like audits and RFEs on I-140s and just life getting in the way as well. So that's one of the real challenges.
Okay,
there.
so that one was failure to timely start the green card process.
Yes, sir.
The next one, Brian, is
side work. It's a favorite topic for me because this is a topic that kind of comes up when we talk about visitor visas in the United States as well. It's about what does the government consider to be work in the United States really, and for me, when you're on H-1B status, you're allowed to work for your H-1B employer, and you're allowed to do the work that is set forth in that H-1B petition, right? That's what you do. But we get lots of questions, and even live during this thing, what can I do on the side? And just as, customs folks, consider things like religious work in the United States, babysitting in the United States. Those are the sort of things that stop up visitor visa applications. Somebody comes to the border and says,
So let's talk about babysitting, for example, because you bring this, it is an absurd example. Not commenting on you, but commenting on USCIS.
I just talked to somebody 2 weeks ago who got turned around at the border on that issue on a visitor visa.
Oh, 100%. So if your friend calls you, say, "Hey, we're going to the movies.
Yep.
Can you babysit our kid? They're on H-1B."
As an immigration attorney, I can't recommend it.
Pretty sad.
Yeah.
Right? Pretty sad. Okay.
Religious work. I was talking to somebody recently who got, I just want to come to the United States as a visitor, and I want to spread the word of my religion.
I honestly think a single incident is not a problem. I think the problem with the visitor visa, Brian, not to digress, has to do with grandma coming in because the grandchild needs help on a continuous basis.
Yeah.
And then the grandma comes in, they say, no, you're taking a job. But if you get a call from your friend that says, hey, we're going to the movie this evening. Do you guys mind come home and watch TV? Just be around. I'd say a single incident is
Probably not. Well, maybe that we move up more into the H-1B specific ones that people sort of get in trouble with. You know, any sort of work outside the terms of your H-1B petition. So let's see, maybe, what if, you start working from home and it's not on your, you're not approved to work from home on your H-1B petition. Your home is outside of your approved work site. That's a problem. How about if, you're maybe joining a company. About to join a company, maybe they want you to meet with their clients before you join. Something that is a real world scenario. What if you're just moodlining? What if you're just your buddy pays you a couple $100 to develop a website on the side? These are the things that we get asked about a fair amount.
And it's sometimes one thing leads to another. You're going to visit your friend because you're bored. Your friend's working in the grocery store, and all of a sudden you're carrying stuff for him, and then.
Yeah. I mean, the classic one where it sort of it becomes a thing like that is I bought a house. And I was going to live in it. Then something happened, so I decided to rent it out. And then, the house needed a little bit of X and Y and Z, and then suddenly I'm a landlord doing my maintenance on my house, and that's my side business, and suddenly you have a whole side gig for yourself.
So side work, avoid at all costs.
Yeah.
What's the next one, Brian?
Yeah.
Benching.
Benching.
Yeah. So benching, it's not something that is in your control most of the time, but sometimes it is. Just be aware that if you are in what is benching? By the way, the definition of benching, it varies.
Yeah.
So benching is not a legal term. You don't find it in regulations. You don't find it in the law.
All I find is coming out of USCIS officers' mouths when.
And even when they talk about benching, it may not be a true benching, because if you're not in non-productive status, but paid, is I think different than non-productive status and unpaid.
Yeah.
And the variety we're talking about here is either, because either can cause a problem in the eyes of USCIS.
Yeah.
And USCIS is struggling to define where's the line being crossed.
Yeah.
And then they come out with this policy, the non-policy policy.
Yeah, well, so
the policy that doesn't talk about anything.
Yeah, so it's always been the position of the Department of Labor that they're happy as long as you're getting paid as per your LCA.
And that's the U.S. Department of Labor.
Yeah, they're happy.
Not USCIS.
They check your pay stubs, they look at your LCA, everything lines up. They're happy. They don't care. But USCIS, they're concerned about, hey, are you being productive? Are you actually doing the work that's on your LCA? And USCIS's most recent version of their benching policy, to the extent they have one at all, not benching, but a policy upon non-productive time. And I will read a little quote from it here. What they say: if the time period of non-productive status is more than what is required for a reasonable position between assignments, that's when they have a problem. What is a reasonable period of time between assignments?
That's nonsense. That doesn't give any direction, but you're right, that's their policy.
Yeah.
It doesn't give any direction. However, it tells you one thing for sure. It tells you that they're looking at it, and tells you that they're giving their officers some discretion to make decisions on a case-by-case basis, and the discretion may not fall in your favor. So if you're not in a productive status long enough, you should be nervous and you should ask questions.
Yeah. Yeah, I mean, how long do you think a reasonable period of time is, Sam? What do you argue? What is the measuring stick that you go by?
Well, I only go by the law, Brian.
Yeah.
I don't have an opinion. I'm a lawyer, right?
Yeah.
My opinion doesn't count.
I got some law I can cite.
I think I go with the DOL, Department of Labor policy. Number one, it is the Department of Labor that should determine whether you are in productive.
It's a matter of labor, isn't it?
Of labor, yes.
Yeah.
But USCIS oftentimes does more than what they're supposed to do. But what's your opinion, Brian?
Well, I say it's got to be at least 60 days. Why? Because there's a 60-day USCIS approved in the regulations grace period. for H-1B workers. So under the grace period, they say, okay, you can maintain status if you're not even employed by a company, not doing anything at all, not getting paid, not employed by a company. So I figure if I had to make an argument, I'd say that's going to be my start of my baseline for what is a reasonable time, at least 60 days. If another guy out there can have no job at all, not get paid, not doing anything for a company, whereas the other guy is getting paid by his company and, working with his company, if it's assuming his consulting company, to find a project, meet with clients to say, here's what I can do for you as a person. I'd say, again, at least 60 days, and I'd argue a lot more beyond that, because if you're working for a consulting company, that's part of your job, is to basically pitch yourself, meet with people to say, hey, here's what me and the company can do for you. That's the argument I would make. At least 60 days, and I'd be arguing a very long time for sure, if anything.
And that's an excellent argument, but this is the kind of things that we do as lawyers. It doesn't mean it's, so people understand. Yeah. It doesn't mean it's written in the regulation or is in fact 60 days. It's an argument we would present when somebody's in trouble.
I guess the counterpoint is anytime you have any period where USCIS thinks you're not, if you're H-1Bs for a software engineer, you're not out there software engineering for 8 hours a day, they can get real interested in that, and they do.
My advice to a lot of people is to go into training, company-sponsored training. Yeah. It may not be productive, but clearly it is something that you're doing every day, which will give you a counter. And the last one is, Brian?
It's the old thinking they won't find out. People always ask me, well, Brian, how would they know that? And I guess my first answer always has to be, well, there's no guarantee that they're going to figure something out. However, there's a reasonable chance that they might. And how does USCIS figure things out? First of all, they look at the things you send them. If there are inconsistencies in the records, in the documents, in the forms you send, the documents you give them, they will, start comparing these things and say, well, you said this here, this here. You've got, you said you were working here on this date and we're working here on that date. Maybe you have a status issue. They do investigations. Sometimes you'll go to a green card interview and USCIS say, the officer will pull out a piece of pink paper that says, well, I have something from the investigations folks. They want me to ask you about XYZ. And sometimes it could be something from, literally a decade ago or more. And those things can come up. USCIS site visits if you're on H-1B status. They'll go there to make sure you're doing what you say they are. Tell me what you're working on. Who are you working for? What's the client? Who do you report to? Things like that. They can look at your DS-160s, compare that to your resume. Sometimes it's amazing what the government doesn't know.
It's capable of finding out.
Yeah, but sometimes it's amazing what they're capable of
finding out.
Yeah.
Absolutely. Well, thinking they won't find out. So whatever you do within your H-1B, make sure that you're following the rules and don't assume the government wouldn't find out. So those are the 5 things under the H-1B visa program that are very important for you to be watching out for. These are the 5 most common H-1B pitfalls that you may inadvertently fall into. And we're going to move on to answering questions now. Just remember, when we answer questions, there's no attorney-client relationship is established. Do not make a decision on your case because you listen to us. Consult with an attorney of your choice to help you make a decision on your case. And we welcome your questions. Bring them over and we will answer them. And we will start with the first one with
Prem US Vlogs.
And let's make that screen bigger, Brian.
Yes,
so
we will make it so we can read it.
Yeah. I applied for my EAD, an advanced parole renewal, in February 2023. As usual, my EAD approved for 2 years and my AP is still pending. Do I get 5 years AP approval? Well, you applied in February 2023. They haven't approved the EAD.
Well, the EAD approved
they have approved the EAD, but not the advanced parole. There is nothing in the rules that says you should not get a 5-year advanced parole because they haven't even came out and provided any policy or details on the 5-year.
On the advanced parole. Yeah, they said, for everybody who's not aware, they said, a couple months ago, maybe sometime back in June, hey, we're going to start approving 5-year EADs. And they didn't say anything about 5-year advanced paroles. Anecdotally, some people have gotten 5-year advanced paroles.
Yeah.
And do you get a 5-year AP approval? Well, my honest answer is why not? Because it hasn't been approved yet. I don't see why not. I would say to you, Prem, have you checked the bottom of your EAD card? Does it say it's a I-512 advanced parole? Because I have heard of a couple times recently of people getting the EAD approved, having it marked serves as I-512 advanced parole on the bottom, and the AP still being pending. Now, the AP processing times are absolutely shameful. Thus, it wouldn't surprise me if you filed in February 2023 and your AP was still pending. But wait and see. I think it's possible, but there's no right or even policy supporting the 5-year AP approvals. I just call it a nice bonus. You know,
they want to get, because it's taking them forever to approve them, and they dug themselves a big hole. And obviously, it's something that they are trying to resolve. So we have a follow-up question
from Prem. Yeah. So my priority date is November 2012, EB2, EB3 India. Will the dates move into my priority date in January 2024 visa bulletin? So
right now, the January 1st, 2012, and he's asking about November, and that's for the final action. And dates for filing are May 2012 and
for
August.
EB3 and January for EB2.
So
India,
it all depends on which dates you're talking about. But in either scenario, the question is in January 2024, which is the next quarter. I just don't anticipate that big of a jump, at least with the final action date.
It wouldn't surprise me if that date came up in this fiscal year. I'd say, oh, well, thumbs up for Prem and call it a day. I mean, May, that's 6 months off of November. Yeah. You know, I don't expect that big a leap on the visa bulletin because we're not seeing big movements on the visa bulletin across these.
Either way.
Yeah.
Yeah.
You would think that if they thought they had lots of bandwidth in the visa bulletin across these last, the first quarter of this year, that they would have moved them much at any degree across these last couple months.
Yes.
Yeah.
All right. Explorer Dreamer. Brian, take it.
Oh. I-94 expired. I did not extend going to extend H-1 I-797, but have a green card EAD AP for 5 years. I'm not planning to travel for the next 4 years. Will run into out-of-status issues. If I travel, do I get an I-94 from advanced parole?
Excellent.
Good.
It's a great question.
Fundamentals question.
Yeah. So obviously, because you're on a green card EAD right now, meaning that you have an adjustment of status that's filed and pending, and it was filed while you were in status, meaning that the I-94 was valid at the time the adjustment of status was filed, and now that you have gone beyond the I-94 date, you're relying fully on the adjustment of status being pending. That's perfectly okay and legal to do, and there's no out-of-status issues. You are not in valid non-immigrant status.
He does have a status issue. He's out of status, but it's not a problem. Is my funny little version of explaining.
Well, you scare the heck out of anybody when you say it that way. He is. I don't say you're out of status. I would say you're not in status.
Yes, there you go.
Because there's a little bit of a difference between them. An out of status indicating that you're in some kind of an illegal scenario. Not in status, to me at least, it indicates that you may be in a different scenario.
Well,
right?
I choose to phrase it that way to point out the distinction. Technically not a status, but having a pending green card in the United States, so it's properly filed, puts you in a period of stay authorized by the Attorney General. If you look at the
language,
what the language it says.
So you're authorized to stay in the United States because you have an adjustment status pending. So there's no out of status issue.
Yeah.
Underlying issue.
I will accept that. Answer.
If I travel, I get the I-94 for advanced parole. They will issue an I-94 for advanced parole, yes, but it means nothing.
Yeah, they will give you. They'll say like a 1-year duration I-94, and it's a pretty common question we get. Oh, and what happens after 1 year? Nothing. You still have a pending green card application in the United States. It makes me sweat a bit every time I get that question because I don't like any sort of I-94 expiring.
Anything with a date that means nothing is a problem because dates mean a lot for the government and for us trying to comply, right?
Yeah.
And then all of a sudden I have a date on my passport.
Yeah.
And then the attorney says, "Don't worry about it." But that's not cool.
I-94 is like have run somebody's life for the last 10 years while waiting for their party to become current. And then we're coming around saying, "Oh, those I-94s don't matter."
Yeah.
It's yeah.
All right, sounds good. Looks most of AP approvals are 5 years, so you can expect it. Somebody.
Yeah, just Explorer Dreamer there. Just telling.
All right, Explorer Dreamer. Thank you so much. All right, wonderful.
Oh, a bit of commentary from Explorer Dreamer. DMV asks for I-94, and in many places I-94 is needed. That is the fun part of the United States here. 50 different states plus some territories, each with their own.
DMV does not always ask for I-94.
Yeah.
And they should not ask for I-94, and it's not needed if you're on valid status.
Yeah, usually they will take. They're happy to give you give you a driver's license based upon an EAD a combo card, or just the EAD itself.
Yeah, it's not required. I mean, you have a pre-authorization document that's valid that you can point to. And therefore, you can go to the driver's license and say, "Here's my authorized stay in the United States. I have an employment authorization document that's valid, and the receipt notice on the I-485 together." And if they don't honor these, you need to contact your attorney because they need to be educated about the law.
Yeah.
All right.
I do like eliminating those common misconceptions. I was told by somebody that.
And I welcome comments like this because it allows us to talk about it more and explore more to answer the questions.
Yeah.
Okay, wonderful. So going on to NAS.
Yeah.
NAS, this is related to H-1B physician. If employer has two sites, one mentioned on the labor certification and also provide services to third party, but also within 10 miles. So some NATS further clarify that based on my knowledge, it's legal to work within 20 miles even if providing services to third party. I'm so happy that you're bringing this up, Naz, because I think it deserves clarification to help you out, not to get into one of the 5 common H-1B pitfalls.
It's a very on-point question.
Maybe we should have had another one, the 6th most common H-1B pitfalls.
Working outside of
number one.
Let's talk about NAS. Let's not scare NAS here.
Yeah. So number one, the 20-mile is not correct. So simple.
Yeah.
It is typically what the law says is you have to be within the metropolitan statistical area. That's an area defined in a map that's published by the U.S. Bureau of Statistics, I believe. So there's a map that's out there that says what is the metropolitan statistical area. Typically, it's the metropolitan area.
Well, yeah, and here it's Columbus, or in the Columbus area, it's Franklin County, and then it's a couple counties to the north, a couple counties to the south, and now all directions around it. Yeah.
Detroit, for example, just so you know, if you're in Detroit, say Detroit has 2 separate MSAs.
That's true. Yeah.
Split, so you can cross one to the other, and then the second rule. So as long as you're within the MSA, metropolitan statistical area, you're fine. But if you have an area like Detroit, which are two MSAs that are touching each other, or within a reasonable commuting distance to the MSA.
Yeah.
So what's a reasonable commuting distance? Do the majority of the people make that drive? Is the question. It's one of these not very well defined areas. So clearly the 20-mile rule, if you're in a rural area, like in the middle of nowhere, and you're in a small MSA, an argument can be made that driving 45 minutes is okay because everybody owns large tracts of land and people commute longer distance to come in and out, potentially. But if you are in other areas, it may not. If people don't commute that far.
Yeah, I mean so maybe to talk a little bit how we would do an H-1B like this. If one of our clients came to us and said, hey, we have a doctor that's going to be doing working at 3 locations around town here, we would just file 3 LCAs for those locations, just for the peace of mind to basically broadcast out there the government, here's where you're going to find this individual if you know those things initially. Beyond that, it is always possible to add, the H-1B rules are based upon MSAs, right? And you're allowed to add work sites within that MSA as long as it's within that MSA or it's commuting distance. So if during the course of your H-1B, you find, oh, hey, we have another work site, well, all you do is, do in accordance with Department of Labor policy, which is also allowed by USCIS, you put another posting up at your new work site location, and you're good,
So now let's talk about this third party
Yeah.
reference. So providing services to third party. Now, I don't understand that language very well. So this was one of two things for me.
Sure.
One is problematic, one that's not problematic.
Okay.
So first of all, if you're providing services outside the H-1B designated area, a posting is required unless you fall in one of the very narrow exception, and this one is not. So if you are at another location and you're providing professional services there, at that location, a posting notice, an LCA posting notice is required by the U.S. Department of Labor. That's number one. Number two, if you are providing a service at that location, but the employer is still paying you, then that's only thing that you need to do to comply is the posting notice. But if the third party is paying you money, that's a serious infraction. That's working outside the H-1B. This is the one that we talked about here is side work.
Yeah, I imagine this is probably somebody where I'm working for my company, but maybe providing services to a third.
Don't assume.
Okay.
Well, especially with doctors and how they do things.
Well, I don't know much about
so
about the
locum,
profession.
they do something called locum sometime. Doctors where they contract to do services somewhere else.
That's what I imagined. Yeah.
But that they get paid directly.
Oh.
Yeah.
Oh.
So they get paid directly sometimes. Now, I'm not saying NAS's case is that, but that's a common thing among physicians where they can go to a third site and contract directly to provide services during their vacation time. Sometimes they do it. Now, if you're being paid directly by that third party, definitely it's a problem. If the employer is paying you and you're just doing work and you're not getting paid directly, then all what you need to do is file the LCA notice.
Yeah. Yeah. I mean, there's all sorts of fun little H-1B related rules. I mean, think about the temporary worksite rules, which we don't have to argue as much anymore. Maybe everybody's a little bit more compliant after they changed policy requiring always filing new H-1Bs for changes of MSAs. Maybe that's the reason.
Yes.
There.
Yeah.
Well, there's Naz's answer. Not to be directly paid. Okay. I guess I would always encourage, it's one thing to be here, but if you have questions about these things, always, talk to your immigration counsel because, we have. I could literally sit here and talk for a half an hour about the nuances of H-1B work sites and is it really considered a work site? Those are the sort of things we do as attorneys in general.
Yes.
Yeah.
Well, guess what, Brian? We get to go home early because we finished our question. We did our homework.
Yeah.
Thank you guys for listening to us today. We will be back next week, Monday at 6 o'clock.
Enjoy the time off.
Yep.
Yeah.